This is a review of trusts for the essay section of the test. Creation of a valid trust requires property, beneficiary, a trustee, and intent to create. Under the common law, unincorporated associations can not be beneficiaries. They can only be a beneficiary under model law. A trustee, it's not fatal if the trustee is absent. A court will appoint a trustee. In regards to intent, the testator or the settlor is the creator of the trust. The settlor must have a present manifestation of intent to create a trust and not just precatory words, which are just wishes or requests that something happen. Trust must also be for a valid legal purpose. If illegal at creation, you excise the bad part. If that's impossible, you invalidate the trust at inception, and the settlor remains owner of the property or assets, or you allow the trustee to keep the property. Types of trusts: you have a discretionary trust, spendthrift trust, support trust, constructive trust, Totten, charitable, resulting trust. A discretionary trust is where the testator is given sole and absolute discretion to determine how much to pay the beneficiary. This, however, must be expressly stated in the terms of the trust. Looking at a spendthrift trust, this prevents the beneficiary from voluntarily transferring future payments and creditors from attaching those payments. And same rules as above on the discretionary trust. Looking at a support trust, this is where the testator is required to use only so much income or principal of the trust as necessary for the beneficiary's health, support, maintenance, or education. And again, same rules as discretionary. Looking at a type of trust and a constructive trust. A constructive trust prevents fraud or unjust enrichment. This is more of a court-created trust. It applies if there is self-dealing of the testator, there's fraud, or if there's a secret trust. At a Totten trust. Totten trust is a tentative bank account trust naming a beneficiary who takes whatever is left in the account at death. Charitable trust. Charitable trust under the restatement is a trust that confers a substantial benefit on society. An example is helping the poor, advancing education, helping the sick, or promoting religion. Charitable trusts are not subject to the rule against perpetuities. If the charitable trust purpose of the charitable trust is impossible or impracticable, the court will use intrinsic and extrinsic evidence to ascertain the settlor's intent and determine si pres, quote, as nearly as possible their intent. Looking at a resulting trust, this is an implied in fact trust based on presumed intent of the parties. This is where the testator transfers property to the settlor if alive, the settlor's estate if the settlor has passed, or intestate takers if the settlor died without a will. And a resulting trust is a result if a trust ends or fails for illegality or for lack of a beneficiary. We got trust modification and termination. The trust can be modified by the settlor only if this authority is expressly reserved in the terms of the trust. A trust can be modified by the court, of course. Termination of a revocable trust. So you have revocable and irrevocable trust. Termination of a revocable trust. Majority of jurisdictions, the settlor may only revoke a revocable trust if that authority is expressly reserved in the trust agreement. Minority of jurisdictions, the settlor has power to revoke unless it's expressly said irrevocable. The majority of jurisdictions, settlor may only revoke a revocable trust if expressly reserved. Termination of an irrevocable trust. Termination of an irrevocable trust can happen if all the beneficiaries and the settlor consent to termination, or if all the beneficiaries agree and all agree to terminate the irrevocable trust and all material purposes of the trust are done. Looking at trust administration and duties, trustee has powers all enumerated and implied, enumerated in the documents and implied. This is to sell property, incur expenses, lease, borrow, to manage the trust for the benefit of the beneficiaries. Trust administration and duties, the duty of loyalty. This is to administer the trust for the beneficiary's benefit. There can be no self-dealing. If a duty to invest, I would focus on the common law prudent person test. This requires the testator to act as a reasonably prudent person investing their own money. And here, good investments are federal government bonds, first deeds of trusts, federal insured certificates of deposit, blue chip stocks, mutual funds. Under the common law prudent person test, there can be no new businesses for investments because it's not a prudent investment, or second deeds of trust. Another authority on the duty to invest is the Uniform Prudent Investors Act. Here, the trustee must act as a prudent investor. And this is as measured in context of the entire trust portfolio, but for the exam, I would focus on the common law prudent person test. Looking at other duties of trust administration and duties, this is a duty to segregate. There can be no commingling with personal funds or trust of another. There is duty not to delegate, and this is under the common law. The trustee can rely on professional advisors but cannot delegate authority to those advisors. Trustee has a duty to act. The trustee must provide the beneficiaries with statements of income and expenses on a regular basis. Trustee has a duty of care. The trustee must act as a reasonably prudent person would if dealing with their own affairs. Trustee also has a duty to collect and protect property, maintain marketability of property, and keep trust property productive. Trust administration and duties and remedies. Remedies for trusts are variable. You have damages. You can form a constructive trust. And again, a constructive trust is formed to prevent fraud or unjust enrichment and implies of self-dealing, fraud, and or secret trust. So you can form a constructive trust. Remedies are damages, constructive trust. They can also have tracing and equitable lien on property that has been mismanaged. You can also ratify a transaction if that transaction is good, and you can also remove the trustee. Looking at liability to third persons, contract and tort liability. On a contract liability under the common law, the trustee is sued in their personal capacity but may get indemnification from the trust. However, the trustee may also, in a contract action, be sued directly in their representative capacity if the contract stated so. Looking at tort liability to third parties, again we say contract and we're going to tort under the common law. Trustee is sued in representative capacity. And if the trustee is without fault, the trustee can get indemnification from the trust. And that completes our essay review of trusts.